Welcome, everyone. Today we're going to do a walkthrough of how to conduct and implement security risk assessment recommendations. This is a critical topic that I've been meaning to bring to our group. Many of you participating today are regular clients of the firm, and I know that some of you have not undergone this process yet, and it's very important because this is one area where patient complaints and government review is on the rise, and there's potential monetary exposure. So I'm going to take you through some basic steps that you can start looking into for your practices to implement that will protect against potential review by the government. Just before I get started, for those of you I have not met yet, I am Jennifer Kirschenbaum. I am the managing partner of our healthcare division at K&K, and I specialize in transactional work, compliance, audit, defense, litigation, and we help healthcare practitioners in all areas of their lives and their practices. We have a general practice group. Today, we're going to talk about how we're going to mitigate exposure through risk assessment. The tool that we're going to go through, which I'm going to show you in a few minutes, is the free, you heard me, free government risk assessment tool that is very comprehensive, arguably duplicative in its questions, but lays out the groundwork on what the government expects each covered entity, which all of you participating likely are as healthcare providers, to abide by in your everyday and in your policy and procedures and how you're protecting patient health information. So that's the link right there, and we're going to go to the actual site. How to use the risk assessment tool, and we're going to go through some of these specifics, and I apologize for it being so wordy, and then I'll show you the tool, is each question we're going to go through on the tool, which is not going to be that many because you can do it on your own time. We're going to consider the threats and vulnerabilities to the IT system and programs we have in place. We're going to document our current activities in the boxes that are provided. And if the current activities do not address all the threats and vulnerabilities we have identified, we're going to have to develop and document a remediation plan. We're going to document the impact and likelihood of any unaddressed threats and vulnerabilities we have at the practice. Not all risks are going to be able to be reduced to zero. And a lot of those that can't be reduced to zero are usually from our human resource side, our people side. There's always going to be exposure because there could be errors that our employees make when they're implementing their tasks day to day and job function. So your organization is going to have to be comfortable accepting some level of risk. And as we get there, we're going to talk about how much risk is acceptable. And that really depends on the type of structure that you're in. What are your resources? How big is the organization? How much of a monetary spend could you reasonably put towards compliance? Lastly, we're going to calculate an overall risk score when you go through this process. And oftentimes your IT provider is going to have to be critical in assessing a certain portion of the questions that are relevant for our risk assessment. This is a chart that's provided actually by the Security Risk Assessment tool, and it talks about what the potential impact may be and likelihood of issue depending on what the problems are that we identify. This will make more sense as we go through what some of the questions are in the risk assessment tool. When we're going through the process, we're going to evaluate the likelihood and impact of a potential risk to our electronic health information. So any systems that we're using, our EMR, how accessible is it to the outside? Do we have people with passwords and access to it that we're not sure they still have? Are we canceling passwords and IDs when employees leave the practice? These are areas of risk that we're going to talk about. Have we implemented appropriate security measures to address the risks identified in our risk analysis once we do it? So one of the things that you're going to see here from one of the cases I'm going to talk about today is if you establish your own standard and then you don't meet that standard or exceed it, you're creating risk and exposure for your entity. And that's one of the big things. So if we're going to do a security risk assessment, which we are all expected to do by the government, we're expected to do a security risk assessment, we are then putting ourselves under the gun to make sure that within a reasonable time frame, any identified risk areas are addressed and remediated promptly. We're going to document the chosen security measures and, where required, the rationale for adopting the measures. We're going to maintain continuous, reasonable, and appropriate security protections to the extent within our means, and we'll talk about that. This is what I'm saying when I say we'll talk about it. The expectation by the government is that each practice will complete an entire assessment, review its overall risks, prioritizing them, particularly those that are unaddressed by current activities, and take appropriate steps to remediate. Now, the paper tool we're going to look at, nor the online tool that the government gives you, is not going to tell you how to specifically remediate risks. It's going to give you tips and advice and certain recommendations, but it's not going to specifically tell you how you can be risk-free, because really no entity is going to be risk-free here. The government considers your resources when they look at whether or not you are complying. They will look to see a covered entity's size, complexity, and capability, its technical hardware and software infrastructure, the costs of security measures that you may have already incurred or would have had to incur to get your system up to a different standard, and the likelihood and possible impact of potential risks to the electronic protected health information that you are responsible for. Covered entities must review and modify their security measures to continue protecting electronic health information. So what is this telling you, this language here? It's telling you that the government is saying they expect you to stay on top of the areas of risk you may have with your electronic protected health information and to continue to remediate. So I want to go now to the tool, and we're just going to go through a few sites. This is a website that I showed before, the healthit.gov website. And you'll see what they have here. It's the Security Risk Assessment Tool, and it talks about HIPAA, and it talks about the agencies that have helped develop this. And then as you scroll down, they have a couple of different versions. They have an interactive, and then they also have a paper-based, which is what we're going to look at, that talks about the 3 different areas a practice has to be mindful of when addressing HIPAA concerns with electronic data. The administrative safeguards we have to adopt, technical and physical safeguards. So the first one of these tools that I'm going to open is the administrative that I have here, and this is the top of it. This is the administrative section, administrative safeguards content of the Security Risk Assessment Tool by the Office of Health IT and HHS. And what they do here is they lay out the areas that they're going to hit. These are all questions of the questionnaire of the risk assessment that they want you to go through. There's a lot of them. There's over 30 or 40 questions. So the first one is, does your practice develop, document, and implement policies for assessing and managing risk? So is this on your radar? Do you have a basic policy with an understanding that you have to be mindful of your protected health information maintenance responsibilities and protection? So we're going to go down to that question. You see there's a lot of other questions here. Some of them sound somewhat duplicative. Does your practice document the results of its risk analysis? That seems a little bit like it's going to be folded into your initial policy. Yes, we know what to do if we analyze a risk and we have to address it, which is a loaded question because you need to have the proper team in place to be able to address these things. A lot of this stuff your IT provider is going to actually have to help you with. Plenty of it an office manager is available, hopefully, to do. Certain lists we're going to talk about, access control, which we'll get to. This is a basic on how the document works. It talks about what we're going to do to go through it. Here's access control mentioned here, and I'm going to go through some of these. Here's our risk chart on how we're going to rate if things are low risk, low impact, likelihood of there being a risk, and we're going to do our own self-assessment with our team that may include legal, it may mostly be your IT providers. So here's how the questions work. And again, we're in the administrative volume of the risk assessment tool. Does your practice develop, document, and implement policies and procedures for assessing and managing risk? Well, let's just say the answer is no. If the answer is no, why don't we? Is it because of the cost? Is it because of our practice size? We're just too small. We just don't have enough people to allocate towards this. Is it because it would be too complex for us to adopt? We can detail what our current activities are if we don't fill this box or if we do. So what level of risk for us not to have any policies related to electronic health, protected health information is there? And what level of vulnerability are we going to have? Well, for us on this call, because we're just getting started, we may not really know how to identify or place a value on likelihood of threat or vulnerability just yet, because we're not really sure what the government is looking for. But let's go down to the related information for things to help consider on how we should answer this question. The government is telling us that an information system that's interconnected under the same direct management control and is sharing the same functionality is going to include our hardware, software, data applications, communications, and also our users. So this includes all of our employees that are using any system that's connected or could be connected to the internet, basically. It includes all of the portable electronic devices that we have, any storage devices we have at the practice, any voice, video, or images, anything that's capturing protected health information at our practice, including our notes and records. So laptops, pocket computers, cell phones, to the extent that anyone is using a cell phone in the office or has patient information on cell phones or has pictures that they're taking in the office, which shouldn't be allowed. Electronic storage media, including all memory devices and computers. So they're now telling you this is what we consider to be your risk areas. These are the areas that we expect to have some level of protection. All computers, all storage devices. Consider whether your practice has an inventory that includes, do we have a list of all systems, including all components, hardware, software, all electronic devices, laptops, tablets, smartphones, and all media, mobile media, thumb drives. Consider whether your practice identifies all spreadsheets, databases, and other software programs that collect, process, and store electronic health information. So each of us, no matter the size of our practice, has some of this, right? We have our patient information documented somewhere, presumably on a device that leads to the internet, whether it's a thumb drive or a mobile phone or a computer. We have all this stuff. So the government goes on to tell us that we may not have adequate controls if we click no, that we don't have a policy and procedure in place. And they go on to tell us some potential impacts that may come up. There could be an unauthorized or inappropriate access to the electronic protected health information that could compromise the confidentiality, integrity, and availability of our protected health information. There could be unauthorized disclosure, loss, or theft if we're not maintaining a list of what hardware we have on file. We need to have an inventory so that way we can track the inventory, and that's one of the basic things here. The government goes on, and we're still in the first question, and don't worry, we're only going to do one question. It gives examples of safeguards. Here are potential safeguards that you might want to put in place to use against vulnerabilities. And they tell us what those are, which is to develop, document, and disseminate to the workforce members a risk assessment policy that addresses the scope, role, responsibilities, and expectations of the organization. So basically set standards for your employees. So to simplify it, when we hire our employees, do we give them an offer letter, do we have a handbook, or do we have something I call a workforce confidentiality agreement where people are coming on board and saying, I recognize I'm coming to work for a medical practice that has an obligation under HIPAA to maintain our patient information confidentially, and I will not take anything out of the practice. If I lose something, I will say something. If I send something to the wrong person, I will say something. And this is what we're talking about with written procedures, to make sure that we have a process in place and also standards for our employees. The administrative rule, as we saw above, section, has a lot of questions, and they're all similar. The second question is, does your practice have a process for periodically reviewing its risk analysis policies and procedures? Well, we should have a process to voluntarily and regularly review. However, as counsel to most of you, I would suggest that we do not stipulate that it's going to be done biannually or even annually, because things come up and we forget. So we could set a policy that we'll periodically review, but I prefer not to set an exact standard on when that is going to happen. So this is the administrative guideline, which I'm going to close. And I'm just going to do one question each on physical, so you can see kind of the difference. So do you have an inventory of physical systems, devices, and media in your office space that are used to store and contain EPHI? No, we have not started tracking. So what are you going to tell us that we're doing wrong? So they're talking here about all buildings and rooms that have data centers, areas where equipment is stored. So now we're talking more about physical space than the actual hardware. IT administrative offices, workstation locations, and other sites. It also is going to include that duplicative component from the administrative guide of hardware, software, and information. Possible threats to the physical facility, natural threats to the EPHI, such as hurricanes, tornadoes, and earthquakes, human threats, unauthorized access, theft. We talked about this with administrative. So examples of safeguards we could have in place. Now, this is physical access safeguards. We can limit entrance to and exit of the facility using keys, right? We can physically lock the premises. We can control access and have a list, document list of who has access to the facility. We could put cameras in place to video record who is accessing the space. We can issue secure keys and other physical access devices. We can establish physical access authorization procedures also. We can issue authorization credentials. Now, we do this, of course, with access to our electronic system, or at least at a minimum we should be, and we should be keeping track of who has access, what they have access to. So again, this is under the physical area of the responsibilities under the security rule. This is the second question. Do you have policies and procedures for the physical protection of your facility and equipment? Similar. This includes controlling the environment inside the facility. No, we have not done this yet. Why? Alternate. We don't want to. Okay. So what are our risks going to be that we have not done this? Environmental threats such as a power failure. If the government were to come in and audit to see how your covered entity was doing, one of the main areas that they are very concerned about is backup. Patients are the owner of their medical record, and each of us are only the custodian of that record. And the government takes very seriously that responsibility as custodian for us to maintain and keep a copy. So one of the main areas that they're going to want to check off if they were to come in for any reason as a result of complaint or random audit, more likely someone would complain and then there would be an audit. Backup systems, fail-safes, emergency systems, that's an area for sure that the government is going to be looking to see in the physical volume of whether or not you are properly protecting. So going to our last portion, which is the technical. This is the first question in the technical section, and all of the tops of these look the same as the administrative, so I didn't want to take you through all of them individually. Does your practice have policies and procedures requiring safeguards to limit access to EPHI to those persons and software programs appropriate for their roles? So this is more technical. Do we have password protection? Do we have limited credentials? Again, no. We have one password for the whole office. We leave the computer unlocked all day. Okay. What are our potential threats? Unauthorized and inappropriate access that can compromise the confidentiality and integrity. Unauthorized disclosure. Accurate EPHI may not be available when needed. So these are the areas they're talking about. How do we fix this? We would develop, document, and disseminate, and enforce workforce members an access control policy, and then also actual physical safeguards. We would have unique identifiers, passwords, preferably. Now, some of you may say, look, based on the IT support that I currently have and I'm willing to spend on, and the level of staffing that I have, and also just how my office works, unique identifiers isn't going to work for me. And I just can't adopt that. I need to keep the same password between my mid-level providers and whoever I'm staffing. It doesn't work for me. Okay, then we should at least document that you've considered and the reasons why. If it's because of the size of your office, how much money you are able to or willing to spend, or for practicality reasons that you're not adopting, you've considered it, you have decided to forego, and I'm not saying that's going to be a total pass for you, but it's better than not having considered at all. So we're going through the assessment process, which is what we're supposed to be doing. That's our obligation. And again, to go back to the slide that we left on, the government considers your resources when they look at how you've done on this risk assessment. Size, complexity, capabilities, technical hardware and software infrastructure, costs, likelihood and possible impact and potential risk. So to boil down some of the basics in the three different areas of what the government will be looking for when you come out of this process of conducting your own risk assessment, they want to see security management process as an administrative safeguard. This is identifying and analyzing potential risks and implementing security measures to reduce risk. They want to see a person actually appointed as a security official who's responsible for developing and implementing security policies and procedures. They want information access management. So they want access control. People should only be given appropriate access based on their role at the practice. So if you, an easy example of this outside of the HIPAA realm, but if you have a front desk person that you just hired as sort of the first in and most basic position, you're not giving that person access to your HR files, right? So if you have an individual who's not involved in patient care at all, why would they have an identifier to get onto the EMR? It just doesn't make any sense. Administrative safeguards include workforce training and management. A covered entity must provide for appropriate authorization and supervision of workforce members who will work with electronic protected health information. So we need to train and manage our employees appropriately, and we need to sanction workforce members who violate policies and procedures. Now, that's not punishing someone for making a mistake. That's different. In the HIPAA realm, you're really only in trouble if you make a mistake and you don't report it. If you make a mistake and you report it, then we can follow the breach notification procedures. We can notify the secretary if we have to. We can notify the individual who's impacted if we have to. But the important thing is for your staff to feel comfortable that they can report up mistakes, because the entity as a whole will certainly have exposure if we are not properly disclosing any unauthorized disclosures of EPHI or protected health information in general. So moving on to the physical safeguards, and then we'll move on to some faster topics, and then go to an example, and I'll show you the OCR website so you can see the back end of this of what happens and why we should be doing these things. Physical safeguards, facility access and control. A covered entity must limit physical access to the facility. So we need keys, access control, workstation and device security. Each of your workstation and devices should be password protected, and there should be safety protocols in place to make sure that we're prohibiting the unauthorized transfer, removal, disposal, or reuse of EPHI. The technical safeguards also similarly are access control. Only authorized persons can access the ePHI. There's talk of audit controls, hardware, software, and other procedural mechanisms to record and examine access. So we want to be able to track and follow who actually has access. And it's important to know who has access to these actual controls. Integrity controls fall under technical safeguards, policies and procedures to ensure that PHI is not improperly altered or destroyed, right? So this is integrity controls. And most of our EMR systems have this built in, that any changes to the patient record is automatically cataloged. And you'd probably have to be pretty sophisticated to know how to unwind that. Transmission security, technical security measures that guard against unauthorized access to ePHI, which rolls us into one of the more complex areas of HIPAA, at least for me, since I'm not a techie, is encryption guidance. And I did spend some time on this last night in anticipation of today's discussion. And I just want to go over some basics with you. What is encryption? I don't know. Sounds complicated. It's a process that takes legible data as input, often called plain text, and transforms it into an output, a ciphertext, that reveals little or no information about the plain text. So I think we all have a general idea of what encryption is, but it takes data that you can read, turns it into data that you can't read, and protects it. There are 2 approved block cipher algorithms by the government. This is the government website, and it talks about 2 different types of encryption. It's AES and triple DES is what the government says is proper encryption. Now, to get a little bit more complicated than what I read about yesterday, there's encryption for standing data that's standing still, just sitting on your system, which is what this AES and triple DES applies to. And then there's encryption that applies also to transit. So let's talk about Gmail, because a lot of you are actually using Gmail, or maybe using an Outlook platform, but many of you are actually using a Gmail or Gmail business platform for your businesses. What about Gmail encryption? Well, I did some research for you and confirmed that Google is using the AES approved encryption standard that the government, and by the government I mean the Office of the Government that is responsible for HIPAA. Oops, sorry, made that bigger and messed it up. The government is approving these 2 different types of encryption that Google is using. So if you're using a Google platform, you can feel comfortable that you are properly using an encrypted system for your information. Now, encryption itself is actually not mandatory under HIPAA. You don't have to have encrypted data. However, if you look at the OCR webpage, which we're going to look at briefly in a bit, if you were somehow to lose or to have an unauthorized access to information that is properly encrypted, technically that would not be a breach, a reportable breach under HIPAA. So this is direct from OCR. That protected health information is actually rendered unusable if it's indecipherable, if it's been encrypted as specified by the use of encryption methods that they approve, this AES or triple DES encryption. So you can rest comfortably if there is access to an encrypted system, and we would still have to document the unauthorized access, but we would be able to come to a conclusion that the information was actually safe and not accessible had it been encrypted under one of these 2 approved standards at the time. And just to kind of circle on that for a minute, or maybe I can come back to this later, it'll make more sense, but the security rule is flexible and scalable to allow covered entities to analyze their own needs and implement solutions appropriate for their specific environments. This is a similar concept we talked about before. What is appropriate for a particular covered entity will depend on the nature of their business as well as their size and resources. So we keep coming back to this. So the real problem for those of you on this call listening is when you call me and you say, Jennifer, am I doing enough? My neighbor's doing this. It's very difficult for me to answer that because it's really a sliding scale, as you see in my picture here. And it's going to really depend on if a patient complains and you're under review, can we show you did enough? What is enough? And that's a bit subjective. But if, this is what I was going to get to later, but I'll say it now, if you are putting preventative measures in place by adopting policies and procedures, working with your IT provider to make sure that we have a level of protocols and access controls in place, and when we become aware of an unauthorized disclosure, we are properly assessing whether with the assistance of counsel or if you elect to do it internally, that's up to you. But we have to show a proper assessment and a rationale on why we've determined whether or not there is actually a breach that requires some form of notification. And if you have these processes in place, we're also going to be careful that we're not over-promising and under-delivering on the processes that we're selecting. And I'll show you an example of what I mean on that. These are just some basics. Is a covered entity responsible if it complies with an individual's access request to receive PHI in an unsecure manner? So no, we can only be responsible for what's on our end. So if we're using a Gmail platform, which is encrypted email, and we're sending it to a patient who's given us their email address, authorized us to contact them by email, and then somehow on the patient's end the information gets hacked, that's not our fault. And we would have to be able to show on our end, of course, that we took reasonable, we put in place reasonable safeguards. So again, do emails have to be encrypted? No, but many of you are actually using systems that are encrypted. Who's deciding on communication? Well, you really are, because you're the driving force under your practice. Are you allowing patients to email with you? Are you engaging with patients through that forum? Can your patients email you directly? Sure, if you're going to allow them to, and we should be confirming with the patients that they approve to be communicated with by email. They are the only ones who access that email. The email address is confirmed. So we just want to be careful about how we're engaging with our patients. Can we use email with other healthcare providers? Absolutely. There's no issue there. We just need to make sure we have reasonable safeguards and how. Some risks to know about before using a mobile device for patient care. It depends, but you could lose your phone, right? You could download a virus by accident. There could be an unauthorized disclosure. So we want to be really careful and make sure that we are protecting our mobile devices, and I'm going to get to another slide on that in a second. Do I need consent to put my patients on a portal? No, you don't need consent to do that. If you want to engage with a patient portal as a third-party vendor, that's fine, but you better make sure you review that contract with your counsel before you sign, because that portal will likely disclaim responsibility for a lot. And if we're trusting the portal, we expect them to serve as our proper business associate. And any HIPAA business that's going on between us, we want to make sure that they're going to hopefully indemnify us for any breaches or issues on their end, on the software end, that we're not really responsible for because we're not in charge of the portal. Here are some protections that we can use for our mobile devices. We want to use a password or other user authentication, which right now fingerprints a lot of us have. We may want to install and enable an encryption on top of what we have on the phone. We should definitely have remote wiping and remote disabling capabilities, because all of our phones have that now, and we want to be really careful that if we lose something, we're able to turn it off or clean it. We want to disable and do not install or use file sharing applications. Try to get a firewall on there, security software, keep your security software up to date. Research apps before downloading them. Maintain physical control of your phone. Don't share it. Use adequate security to send or receive information over public Wi-Fi networks. Be really careful on public Wi-Fi networks. Delete all stored health information before discarding or reusing the mobile device. Affinity Insurance got in a lot of trouble, a heap of trouble, years ago because they returned copy machines without deleting the memory cards on the copy machines, and they were fined a tremendous amount of money for not having swiped clean the copy machines. You don't feel as bad because it's an insurance company, but just an example of areas of exposure that you may not think about. You may want to turn off Bluetooth capabilities to non-discoverable on your phone so no one else can kind of hack in there. And for some of us, this is over our head. We don't think about these things. We take for granted the sophistication of the devices we're actually working with. But we really have to be careful and work through our policies and procedures with the professionals that we have available to us. Your IT provider is critical. If your IT provider does not have a background on HIPAA, you really need to get more specialized in that area because it's a tremendous area of exposure right now. Patients can very easily complain. And to show you where they can complain to, I want to spend some time on the OCR website. Okay, so this is HHS's website for HIPAA. And the office that is responsible for HIPAA is the Office for Civil Rights. It's the arm of the government that enforces HIPAA. So I selected on this page HIPAA for professionals, right? So if you want to see how I got here, let's just go to OCR. We'll just search that in the Google. Oh, look at that, it didn't come out. Here we go. You could also type in Office for Civil Rights, but here's the Office for Civil Rights page, okay? We go to Health Information Privacy. HIPAA for professionals is how I got here, okay? And this talks about the privacy rule, security rule. This is really the boring part that none of you guys are going to want to read. But when you go here, it talks about breach notification, breach reporting is here. When do you have to submit? If you have a laptop stolen with more than 500 individuals on it, we have to report immediately to the secretary, and we also have to report to the public, possibly through a news station. It's a lot. There's frequently asked questions that are very easy to access. So let's say we want to learn something about our patients, protected health information. Let's see what they have. Do we protect genetic information? Yes. Genetic information is health information. Like any other information, it has to be protected. So it's very easy to use. I like the website. I think you should spend time on it. I want to go through some of the news releases, or one in particular. They like to boast on how much money they are assessing for non-compliance from providers, and that should be interesting in a scary way to us, and also interesting in a car accident way to some of us, I guess, just to see what some of our colleagues have done terribly, terribly wrong, but also scary because this agency used to be one of cooperation with healthcare providers, and now it is a punitive agency that is looking to recoup lots of money. So here, an allergy practice pays $125,000 to settle a doctor's disclosure of patient information to a reporter. So this happens all the time. I mean, my clients get phone calls all the time to participate in certain articles. Here, an Allergy Associates of Hartford doctor had to pay, or the practice paid for the individual, $25,000. Let's see the press release. A patient contacted a local television station to speak about a dispute that occurred between the patient and the allergy doctor. The reporter subsequently contacted the doctor after the doctor was smeared, right, for the doctor to comment, and the doctor impermissibly disclosed the patient's PHI to the reporter. So I tell my clients this all the time, and some of you may have heard it from me. We'll go through this. If you have a patient who reviews you on Yelp or some other some other platform, you cannot discuss, even if a patient brings it up, their protected health information. It's not a level playing field. It's not fair. But here OCR says it, the director himself, Roger Servino, when a patient complains about a medical practice, doctors cannot respond by disclosing private patient information to the media because egregious disclosures can lead to substantial penalties. Covered entities need to pay close attention. I mean, this is hardly fair. I'm sure the doctor was smeared really well by this patient. So this is one that I wanted to go over with you because we're specifically talking about the security risk assessment today. This was unbelievable to me. This was a hospital in Texas that University of Texas MD Anderson Cancer Center that had to pay almost $4.5 million in civil monetary penalties imposed by OCR. Why? Why did they have to pay that much? Well, in 2006, they put in writing somewhere that I don't know who wrote it down, that they were going to use an encrypted system. Then, years later, in 2012, 2013, they had 3 separate data breach reports. So they actually made reports to the government involving the theft of unencrypted a laptop and 2 unencrypted USB thumb drives. So they self-reported that over 33,000 individuals had been impacted by these storage devices being lost or stolen. OCR came in and found that in 2006, this organization had committed to only using encrypted hardware. OCR skewered them and said because they committed to an enterprise-wide solution and they failed to encrypt, that they were subject to a massive monetary penalty. The counter from MD Anderson, who fought OCR in the administrative realm and fought OCR in the court realm after, was HIPAA does not contain an obligation to encrypt. And in fact, the system had run into hurdle after hurdle in trying to adopt encryption to the extent that they had thought they would in 2006, and instead elected other security measures. It's not that they weren't paying attention to HIPAA, it's that they didn't feel that they could adhere to their lofty aspirations of 2006. And they were punished for that. They were punished for that in, at this point, I believe, a non-appealable way, and they're going to have to pay for it. Not only are they down almost $4.5 million, but imagine the legal fees here of going through the initial dispute with OCR, which for a system this big and for who they may have hired for this, and then going through the administrative forum for challenging, and then the court system, they could easily be close to $1 million in legal fees as well. So it is just absolutely a devastating number and really preventable. So we're at a different scale, many of us on this call. I know many of you personally, and I am very familiar with your practices. So what I would say is that I am imploring you to take a look at this website where we can download the tool and we can start doing our own little assessment of where can we possibly, do we need Jennifer to do a couple of policies for us, maybe get our employees to sign something that we don't have in place already? Do we need our IT provider to step in and possibly make our server area a little bit more secure, help us lock down some more passwords? Do we need to designate to our office manager access control, meaning listing out all of the hardware that we have, that we've disseminated, lists of employees and passwords, a process to terminate employee access to the system if they are terminated or quit. These are the things that I think are manageable for most size practices, and what I would highly recommend that we look to adopt, if we have not already, in the very near future. So that's really all the time that I wanted to take today. All of you are on our newsletter because that's how you found out about today. If I can, I'll try to take some questions, which I think you can write in the questions section. Oh, I did get a question. Sorry, they're so hard to read here. Are the slides available? Well, the webinar will be posted on the website. So for physical access to the office, are there special rules over the building manager and office cleaning crew, which the building supplies? So if we can, and again, I try to be reasonable with you guys, you know that, if we can get them to sign it, the cleaning company or the building, or the landlord who may have access to the space also, really should sign a business associate agreement because they have physical access to the premises, and we should have in place an agreement. What a business associate agreement is basically saying that I am affiliated with the covered entity, with the medical practice, in a way that I might be exposed to or have access to their protected health information. And while I am accessing this information, I will be careful not to remove it or to disclose it in any manner or replicate it. And I will only have access to the protected health information to the minimum extent necessary that is related to my access of the space. So best case scenario is the cleaning company signs a business associate agreement. Your IT support that's coming in and helping you with this project has to have a business associate agreement, of course. Your Verizon internet that has no way to look at your system does not need a business associate agreement. But this is a standard form. If you don't have one already, you can, of course, ask me. We do them as boilerplate forms for you guys off of our website, which many of you are familiar with. But if you have one from me, then you have what you need, and you don't need me to fix it. If you need me to go through it again, I can. But the business associate agreement is here, which we discount for all of our regular clients. We take 10% off. And then the workforce confidentiality, we have it as part of a package. But I guess if anyone is looking for just that document, whatever time it takes Taryn to put it together for you is what we would charge you for that document. But that would be for your staff. If you want people to sign something to make sure that they are that your individual staff members are going to be responsible if they mess up. And I'd like to hold them to that if you have an individual who sends an email to the wrong patient or hands the wrong exit form to the wrong patient, I don't care that they did that. I care if they don't tell you. If they realize, oh, I auto-sent to the wrong email address, which we're all guilty of at some point, of accidentally, being too quick, they need to recall that message. We need to get written confirmation from the patient on the other end who got the wrong patient's information, that they discarded it. And there's a process, there's a breach notification process also that we have to follow that would require documenting and writing up what has happened and how we are correcting it. So that's a different discussion, which we can go over and do sometime soon. That would be short, maybe a 15-minute lunch webinar that we can cover, that I'll schedule, that is also equally important as this. But today's conversation, which I'll leave you on it again, is the security risk assessment tool, which if you were to Google security risk assessment tool, it's the healthit.gov website. Okay, so if anyone has any additional questions, you can always feel free to email me. I'm happy to use them for the listserv. Thank you for everyone's time, and I hope that this was helpful. Have a great summer.